All right. The chapter 12 is negotiated justice and the plea of guilty. All right. So what this chapter consists of is the three most common types of plea agreements, influencing bargaining, Boycott versus Alabama, and the major reasons why courtrooms engage in plea bargaining, and why cases go to trial when defendants, when they plead that they're guilty, and crime control, and opposing plea bargaining and different reasons. All right, so then some of we have some of the definitions like plea bargaining. The defendant pleads guilty with an acceptation of receiving consideration from the state. You change bargaining when defendant pleads guilty in return for a less serious charge. Count bargaining, defendant pleads to some of the original court's charge and prosecutor dismisses the rest. And then sentence bargaining is defendant pleads, to the original charge in exchange for a promise of leniency and sentencing. So all these sounds like the defendant does plead guilty and they get something in return, depending on, I guess, what they're pleading guilty to and what the type of crime they are, committed, or they are charged for being committed. So I guess depending on one of these, it's kind of like your loan and your sentence, and that you're getting a better deal in a way. So you won't have to go away for as long, or you're getting some kind of thing. You get something in return, for, I guess, admitting that you're guilty to the crime. Also, just mentioned caseload, just when the courts actually have too much cases. So among jurisdictions, and the ratio of pleas to trials primarily reflect differences in prosecution and the police, not in crime rates or court resources. So the discretion with two cases are never the same. And then you have, the cost and risk of the trial and what to do with, the guilty, depending on that's like the sentence, where I guess they're going up in jail, and I guess the amount of time they're going to do in jail. So the prosecutor is certainty of the conviction, control of the negotiation process, and they deliberately overcharge the defendant. The defendant is a lenient sentence, and they have immediate release. So then judges, they pressure attorneys to accept pleas. They know that the going rate on a judge will accept a plea bargain for each charge, and the defense attorneys, they assess the offer and negotiate the terms of the plea bargain. And we talk about the decisions of bargaining. So there's some things that they keep in mind when doing this. It's one of the things is their criminal record. So depending on the defense, depending on their criminal record, depending on what they've done in the past, what laws they broke, what they've been charged for in the past, and just their history. How strong the prosecutor's case is. If it's a strong case, it doesn't look good for them. But if it's not too long, if it's like kind of like if not too good of a case, the evidence is kind of out of order, everything doesn't really seem to add up, they have a better chance. And I guess the type of the seriousness and type of crime that they committed. We also talk about why the cases go to trial, and just there's a three strike rule for prosecutors. So if someone's on their third strike, then prosecutors can actually threaten him with like a very long sentence compared to their first or second strike. Then we have Santo Bello versus New York, gambling and possession of gambling records case, felonies in New York law, plea to one charge, and then the judge was assigned to a new case. Well, the district attorney and judge assigned to a new case, breaching the terms of the plea agreement. So they broke that plea agreement. The promise has to be fulfilled for this. So when you cop in a plea, you have to accept a plea, which is the Alford plea. So that's when Alford versus North Carolina in 1971, same effect as the guilty plea. So that kind of wraps up this chapter. We talked about different plea agreements, which is pretty interesting. I never actually realized how much different plea agreements there actually were. We discussed the major factors are bargaining and discretion. We talked about some of the cases, like Boykin versus Alabama. We also talked about Santo Bello versus New York. We indicate why some go to trial, some of the cases go to trial, and why most defendants do plead guilty, because I think when they plead guilty, they're they make a deal with the prosecutor, they get a better deal if they plead guilty, and they're willing to take that deal. And I think a lot of it is a scare technique. The prosecutors scare the defendant, being like, if you don't plead guilty and get this deal, you're gonna do a lot more time, and this gonna be a lot more worse. So I think that's a big reason why. And yeah, so that's about it.